Hello, everybody. Sorry, I'm having technical difficulties. I'm trying. Billy wants to help. Ava. Ava, come on in here. You get your treats first, baby girl. Come on. Oh, I need to click a button really quickly here. Oh, you guys know that Fridays are hard for me just in general. And then you add on life on top of it. I just couldn't call in sick another day. There we go. I got the button clicked. There. Oh, look at these cats. I got Snitch right here, Billy, Earl's back there. Tiny's around here somewhere. You think they know what time it is? Well, it doesn't, mean anything that they've been whining about it for over an hour now. Special kitty crack. Oh my goodness, you guys. Here, let me put your toy down. Put this down. There. Oh, sorry. Oh, they're gonna be mad. Here we go. Jeez, Ava. Here you go. I'm coming, Earl. I'm coming, Billy. I see you, Snitch. Come on, Snitch. Here, Tiny. Here. Eva, you want one more, baby girl? Come on, Eva. You're a good girl. Yes, you are. Hey, Snitch. Hey, Snitch. Hey, quit pretending you can't hear me. Quit pretending like you can't hear me. Naughty boy. Here, Eva, move. Let's see if one of them joins the co-host chair. You gonna join the chair, Ava? Come on, Eva. Come on up. Oh, man. Yes, I took a shower right before our stream. No, I haven't learned my lesson yet. Hello, Nana Laura. Hello, Wolf Lore Lover. Hello, Anna Banana. Hello, Buzzy Pug. Hello, Wire Mother. Hello, Jerry Matthew Boyd. It's alright, I was late anyways. Sorry. I'm sorry. I woke up and I was in such a good mood and I felt really well. We got some rain, so it kind of cut on the humidity. And then about 2 o'clock, the soreness set in. I was physically exhausted, but mentally sharp as a tack. I hate that combo because it's like, do I nap to get rid of the pain, or do I power through it because I'm not tired? Turns out I was tired. Let's see here. Hello, Jen Callum. Hello, Dark Zoomy. Live long and prosper. Hello, Spider-Man. Oh, yeah. He starts. Tonight he started at about 9:30. Sitting on the tower, meowing. And I would say, it's not time yet. And he would move to a different shelf and meow. And I would say, stop it, it's not time yet. And then he would come scratch me on the back of my shin, my hind leg. And I would say, stop it, it's not time yet. It's almost time. And he jumped back to the shelf. And this went on until just now. I love Earl so much. Ava says it's time to scrounge for treats. That's what Ava says. Right, Ava? Oh, hi, Snitch. Oh, Snitch is in the co-host chair. Oh, he wanted to be by Mommy. Yeah, a little bit. Yeah, I need to take my allergy meds and I still need to take my inhaler. Figured I would do that. Oh, I got coffee. I was like just a couple minutes late because I had to fill my coffee because my thermos is empty. And I hit the brew button right before I jumped in the shower. You can keep it. I don't want anything to do with that. Nothing at all. No. Oh no, happy birthday, Anna Banana, honey. I'm so sorry. We love you and we are here with you. I'm sorry I didn't know that it was your birthday on the 29th. We would have celebrated. Oh, popular day. Yeah, that's about what it is around here. But even though the temperatures come down a bit, the humidity is still, well, I mean, it's raining, so yeah, it's actually, it says it's 63 right now, but well, it might have cooled down since I was out there last. It's been a little bit. I think I gave a potty earlier. I love playing dice. I do. I have a special jar of change that I use for it and everything. I'm sorry. Hey, I had to start a YouTube channel just to have people to hang out with on my birthday. It worked. I'm not familiar with that game. I usually play Street Craps. That's my fun. 7-Eleven Street Craps. They're fun. Otherwise, if I go to the bar, I love the Shake of the Day. And I hardly ever win on it, but I love it. You know, just that thrill that you might win that pot of dollar bills. Might. It's about the only way I'm going to see that many dollar bills all at once. Considering I'm no good on a pole. Ship Captain Crew. I have not played it. We used to play that in Discord all the time. Oh, that was our favorite. Oh, we loved Farkle. Farkle kind of fizzled out, but we even like were coming up with t-shirt ideas for it. Oops, I farkled. Yeah. It used to be a fun thing. We did. Oh, tiny kitten laying at the door. And Ava's still scrounging for treats. All right, so we're gonna kind of jump all over tonight. We got Thurston County, we got Kansas, we got some Michigan. We're gonna have a fun night. And there was stuff that I saw earlier that I wanted to play, and I just couldn't for the life of me remember what court it was in. I just know it was good. So I might have to tackle that on another day. Hello, the Bat Mom. Good to see you. So let's get right into it. As long as I don't have that screaming gal on. Considering I have no idea what you're talking about, I'm gonna go with no.
Is it him again? No, it isn't.
Yes.
All right, and sir over at Nisqually Olympia, what's your name, please? Sir in the jail, your name, please?
Are you talking to me?
Yes, I am.
I recognize Mr.
I couldn't
Wallace.
understand you. My ears are pretty plugged up.
It's Mr.
Mr. Wallace, he was in court yesterday.
Okay, Mr. Wallace, today you're in court for your arraignment. The charge against you is violation of a protection order, and the city of Olympia alleges that that occurred on July 30th. All right, Mr. Wicks.
Thank you very much, Your Honor. At this point, I think I have to object to probable cause. Having read through the statement here, it sounds like Mr. Excuse me, Mr. Wallace had a court date that he was ordered to appear at. It sounds like the alleged victim in that case chose to come to court as well. There's at least my reading of the probable cause materials, I didn't see anything that says they came in together. I see some things that indicate she was waiting for him after court. And based upon that, he was taken into custody. So at this point, I'm objecting to probable cause. However, to proceed forward, I'll acknowledge receipt of the complaint, waive formal reading, and enter a plea of not guilty.
Okay,
Yeah, you didn't hear that at all.
okay. All right, and then I've got to disclose that now that I've seen Mr. Wallace here today, I myself am a witness to some events that occurred in this case in the lobby of the courthouse. So I'm going to recuse myself from hearing any more of this case. And all I can do at this point is set the case on for another judicial officer to hear it who wouldn't have a reason to be excluded. So I'll probably do that by having Commissioner Stillwell come in here when he has a moment on his calendar and hear Mr. Wallace's case.
Okay, I don't think I heard it all, but you saw something. And I'm not sure what you're referring to.
So Mr. Wallace, what he's saying is because he saw something, a different judge is going to come in and deal with this case because he can't be the judge.
Oh, okay,
So just wait a few minutes, all right?
okay. You disqualified yourself?
That's what I did, Mr. Wallace. So we'll have a different judge come in here a bit later and hear your case, all right?
Thank you. What was that all about?
Well, they gotta get a.
Good afternoon, Your Honor.
Good afternoon. Okay, I will need a little filling in here. The only thing I know is there was a conflict.
Does the court have a copy of the police report? We're here for arraignment and we're gonna need to establish probable cause and conditions.
Okay, what name, please?
This Patrick Wallace, Wallace, and the cause number is 2026628. It's a violation of a protection order, domestic violence.
And I do have a probable cause statement. Give me just a moment, please, while I read through this. There in Nisqually, are you Mr. Wallace? No response. Mr. Wicks, is that Mr. Wallace?
Oh, you're speaking? Sorry.
Yes, Your Honor, it's Mr. Wallace.
I'm sorry, I didn't think it was me that you were speaking to.
That's all right. Just wanted to verify who was on my screen there. Okay, I do find probable cause for one count of violation of a no contact order. And
Your Honor, if I may be heard as to
it
that.
would be- just a moment, counsel. And I am rereading through here because I am not certain. Okay, I do see what I needed, and that would be domestic violence. And quite frankly, there's likely an attempt here as well. Counsel, go ahead, please.
So, Your Honor, I'd ask the court not to find probable cause. And the reason for that is Mr. Wallace had a court date scheduled for yesterday. So he was under court order to appear. He goes there. There's actually no allegation that the two walk into the courthouse together, rather that they are both in the courtroom together. Of course they are. There is a hearing scheduled for a case in which he is the defendant and she is the alleged victim in this case. If they, the fact that she walked out of the courtroom and chose to wait for him is her prerogative, but there's no additional detail that gives the court any reason to believe they entered together, that he was waiting for her, anything like that. Now, I wasn't there. I don't know what happened, but just looking at the four corners of the police report, it's insufficient. And I'd ask the court not to find probable cause.
I was there, Your Honor. If the court wants to swear me in, I can add some additional facts.
Okay, Ms. Vitale, do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
So she saw stuff and the other judge saw stuff. I'm thinking stuff happened.
I just wanted to let the court know that I was in the courtroom when they entered together. I will let the court know that I was asked by my coworker if the court could identify the female. The court asked for the female's name. It was the victim in this case. The court asked that the female leave because they were not supposed to be together, and she left. I went outside. I took a break and walked outside, and she was still waiting, and the court had asked her to leave. So I was in the courtroom. I saw them come together. I would ask that the court find probable cause for violating the no contact order.
Did you take a break? Or were you trying to catch her because you knew better? I'm thinking you knew better.
Well, the initial part of seeing them come in together is sufficient. I do find probable cause for one count of violation of no contact order. Okay, as far as arraignment, I understand that has not taken place yet. Mr. Wicks.
That's
have you had
correct.
opportunity to speak to your client about the elements of the offense and about his rights?
I have, Your Honor. I've discussed with him what he's charged with, as well as his rights and his options at this hearing, and some of the risks and opportunities associated with those options. And at this point, we'll acknowledge receipt of the criminal complaint, waive formal reading, and enter a plea of not guilty as to that count.
Thank you. Looks like there is appointed counsel, unless I'm misreading this, appointed counsel on the backup matter. Is it appropriate to appoint the same counsel?
Yes, Your Honor. I believe the appointment of public defender is appropriate given his financial situation. I don't know if the court is in the practice of appointing the same attorney automatically or going to Olympia Public Defense first. It's been a while since I've handled one of these dockets, I'm afraid.
Generally speaking, I can just send it to public defense to be farmed out to whomever.
Okay.
It just is often faster if I direct a point to whoever is already working on the other matter. But with that said, I'm happy enough to just say, based on my understanding of the situation, I will appoint the City of Olympia Public Defense to represent Mr. Wallace. I have found probable cause. I'll enter a plea of not guilty. Does the city have any request on conditions of release?
Yes, Your Honor. Mr. Wallace has a 2009 assault strangulation. That is with the same victim. And then we have the pending assault in our courtroom in which the no contact order stemmed from. So he has a pending charge in our courtroom, also with the same alleged victim. In the assault case, I will let the court know that there was a third party that called in and saw the victim on the ground. And the victim had repeated that several times, that he just pushes me around like he always does. So in that case, the court had ordered, I believe it was $2,500 bail on that assault matter ending in 569. The city is requesting on that case bail be increased to $5,000. And on the new charge, of the violation of the no contact order, the city is requesting bail in the amount of $5,000 as well. Conditions also to abide by the no contact order, have no new criminal law violations, and return to all scheduled court dates.
Okay, thank you. Do you wish to be heard on that, counsel?
Yes, Your Honor. So, as for both of the pending charges, Mr. Wallace vehemently denies them. He also, I would note that assault to strangulation case is 17 years hence. We're very far removed from that. And I certainly wouldn't want to be judged for something I did 17 years ago. With that, he has no warrant history whatsoever. As Your Honor knows, there is a presumption under the rules or the criminal rules for courts of limited jurisdiction that a defendant in a non-capital case such as this one will be released on their own personal recognizance, absent a showing of danger to the community, likelihood of violating court orders, or failure to appear. There are less restrictive alternatives here, and Mr. Wallace is asking the court to impose them rather than setting bail in the amount of $10,000. As Your Honor knows, he's public defender eligible, and in light of that fact, $10,000 is simply excessive based on his ability. Thank you.
Thank you. Yes, there is a presumption of release.
Yeah, but we have a man that, I don't care if it's 17 years removed since his last violent assault against this woman. It occurred in the past, and it has occurred now. And the victim herself claimed he always does this. So we can just assume that those 17 years were not pleasant for the victim. Granted, she's not doing herself any favors by doing things like waiting outside the courtroom for him and attending his hearing. Well, maybe she is doing herself some favors because he'll get locked up longer. But why is she still there?
As I'm sure both counsel know, I'm going to quote from a Fourth Circuit case here. Presumptions are the bats of the law that flit away in the light of facts. I believe we have sufficient concern for risk to the alleged victim, as well as risk of violating court orders. And I am going to impose bail. I am going to leave the assault 4 at 2.5 at 2,500, and I will impose 2,500 on the new charge as well. What do we have for a next court date, please?
August 13th.
August 13th at 1:30 will be your next court date. Mr. Wallace,
Yes,
in the event that you are able to make bail, you are not to have any criminal law violations. You are not to have any contact with Patricia Wallace, and you are to obey all existing no contact orders. Do you understand that? You're nodding.
yes, sir, I do.
All right, thank you. Just a moment while I fill out this order. Okay, I'm re-signing that order. Anything further on this matter?
Nothing.
Not at this time, Your Honor.
All right, thank you. Mr. Wallace, you can step back and have them send the next person in, please. Thank you.
Do what? I'm sorry.
You can let the jail know that they can send in the next person, please.
Does that mean
I believe they've figured it out already.
Oh, okay. So do I leave now?
Yes, sir.
Okay. Do I go home?
Okay. That should be the calendar. Okay, it sounds as though actually that may be the entire calendar. Does anyone see anything that was not covered?
No, Your Honor, I think that was it. Thank you. Thank you for coming
As
in.
do I. Thank you for your
All right.
time, Judge. Appreciate it.
Yeah, I appreciate it.
Certainly.
Well,
Thank you. Have a good day.
Sir, at the Grand Traverse County Jail, can I please have your name?
Yeah, Thomas Sabrin.
Okay, so I will call case 268531 SM1. Mr. Severin, how do you pronounce your name? I apologize.
Sabrin. It's okay.
Sam. Okay. You are appearing for arraignment purposes this afternoon, and you're appearing with Ms. Farrar Wilbur, who is the defense attorney with the Michigan Indigent Defense Commission, here to assist you. Ms. Farrar Wilbur, did you have the opportunity to review the allegations on the complaint, nature of the offense, and possible maximum penalties? With Mr. I apologize, is it Sabarin?
Yep.
Good.
Yes, thank you. We did have the opportunity to review the complaint as well as his rights. At this time, Mr. Sabarin waives a formal reading, pleads not guilty, and will represent himself. However, he is not waiving his right to counsel in this matter.
So in that case, we will enter that not guilty plea on your behalf. In that case, the next step in the process is a pre-trial conference. It will be scheduled for August 18th at 9:30 a.m. and that's in person here at the district court. And to make sure that those notices go to the correct address, I want to get updated contact information from you. So what's a good mailing address?
RD, Traverse City, Michigan.
And a good phone number?
Yeah, 616. 616.
And a good email?
I don't have an email address right now, ma'am.
Okay. In that case, if you do, it sounds like you're indicating that you wanted to hire an attorney, so make sure if that's the route you choose to go, that you pay attention to those court dates and make sure that you get a hold of an attorney in an appropriate amount of time, okay?
Yes, ma'am.
Okay. Ms. Farrar-Wilbur, it does not appear that bond has been set in this case. Is there any information I should know in regards to bond?
Yes, thank you. At this time, Mr. Sabarin requests the court consider a personal bond in this matter. He does have a okay. Can I please have a breakout room with Mr. Sabarin before we go further? I see he's raising his hand. Thank you.
Is it okay to speak?
Nope, hang on just a second.
Yes, ma'am.
All right, welcome back. Ms. Farrar-Wilbur, is there any information that the court should know?
Yes, thank you. It's my understanding from Mr. Saborin as well as Sergeant Bates there at the jail that Mr. Saborin already was given a personal bond in this matter. And we would request that that's continued. Does the court have that information?
I do not. If he already was given a PR in this case, then why is he here?
He has a hold out of the circuit court. He is scheduled for a probation violation hearing tomorrow. And he anticipates that with the resolution of that matter, he would be able to be released as long as this is still on PR status.
All right, so that's why you're appearing before me today. I am aware of that hold in review of the reports that were completed in this case. Okay. So I understand that you are requesting a PR bond. I am not inclined to do that based on your probationary status as well as the information that is listed in the reports. So for those reasons, I will do a $5,000 10% bond. Conditions of that bond will be that you cannot consume or possess any alcohol, any illegal drugs and mood-altering substances, no marijuana, and no non-prescribed medications. You must provide copies of all of your prescriptions to the district court clerk within 48 hours of your release. You must submit to discretionary PBTs as well as discretionary urine screens, the benchmark urine screen, and 2 times monthly urine screens thereafter. You may not use or possess any weapon of any kind for any reason. You cannot engage in any threatening, intimidating, harassing, or violent behavior towards any person, and you must be respectful of all court employees, service, and/or care providers. You cannot have any contact with any known drug user, drug dealer, or felon, and you must obey all lawful commands of law enforcement. Do you have any questions regarding those bond conditions?
Yeah, ma'am, can I just have you reconsider and give me a PR bond? I'm not going to be able to come up with any money to get out.
Great, so you have been assigned an attorney at this time.
Mr. Saborin, he's representing himself.
He's representing himself. So you are always welcome to submit something to the court and wait for the judge to review that bond. I am concerned about public safety at this time. I understand that you are not eligible for release today either, until you have a probation violation arraignment tomorrow. So at this
That's correct.
time, I believe my bond is appropriate in taking into all those considerations. So I will.
And
keep
how
my
much is the
at
bond?
It's a $5,000 10%, so you'd have to post $500.
I'm not gonna be able to do that.
Okay.
And if I have one more question for you right quick. If I'm able just to plead guilty on this today, what would happen?
I am not able to take that plea.
Okay.
I don't know that a judge would be able to do that today. And then you would still be scheduled out for additional court dates.
Okay.
Okay.
So, like, why would I be given a PR bond and then it taken away when I didn't do anything for it to be taken away?
I did not give you a PR bond. This is a misdemeanor case. You are here for an arraignment, and I impose bonds at the time of arraignment. So even if you were to have gotten out, which you would not be eligible for because of that probation violation hold, you would still be eligible for an additional bond at the time of that arraignment. Okay?
Yeah, thank you.
Right. You're welcome. Thank you.
All right, Mr. Lamson.
And Heath, before you go, I think there's one other case that looked like you were appointed on Mr. Washington.
On Ernest Washington?
Yeah.
Brand new appointment.
And he's
brand new appointment.
He's in custody. We can call him next. And just, this isn't, I think we can state this because Mr. Wilson's not here. It doesn't prejudice him. I just got a note. It looks like a CSO affidavit, Ms. Johnson, was filed February 26th of 2025. I think that's the corresponding affidavit to the motion to revoke. So
Okay.
I will note that in my file and review that. I just didn't scroll that far down. So, okay.
And
Thank
Your
you.
Honor,
Yes, sir.
that might be a previous affidavit. I think that was filed and then there was a motion to revoke previously.
Yeah, there's
It was
a motion.
taken up.
February 26th, you're right. Ms. Johnson, if you just look into it and just send me an email with Mr. Lamson on it, if I'm mistaken, just direct me to what affidavit is corresponding with the most recent motion to revoke probation.
I think seeing the lawyer in his fatigues is the absolute coolest thing. He's holding court from the battlefield. I mean, heck, we usually see them in their vehicle, but not in their fatigues. That is great. That is amazing. I absolutely love Lamson.
Okay.
Thank you.
Mhm.
All right. Let me get to Mr. Washington real quick.
Good morning, John.
Good morning, Mr. Washington. How are you?
I'm good.
Good.
Thank you.
This is State of Kansas versus Ernest Washington, case number MGI 2026 CR 211. State appears by and through County Attorney Melissa Johnson. Mr. Washington appears in person in custody from the laptop computer Zoom application, along with counsel Keith Lamson. This case comes on for a formal first appearance. Mr. Washington, the county attorney's office has filed a complaint information on June 29th, 2026, alleging 3 counts. Mr. Lamson, will you go over that complaint information in detail with Mr. Washington?
I will, Your Honor.
All right. Very briefly, Mr. Washington, I'm just going to tell you what those counts are and the severity level of those. Counts 1 is alleging burglary as a severity level 9 non-person felony, which carries with it a penalty range of between 5 and 17 months in prison and or a fine up to $100,000 with 12 months post-release supervision. Do you understand that, sir?
Yes.
Count 2 alleges interference with a law enforcement officer as a level 9 non-person felony, which carries with it a penalty range of between 5 and 17 months in prison and or a fine up to $100,000 with 12 months post-release supervision. Do you understand that, sir?
Yes.
And count 3 alleges criminal use of a financial card as a Class A non-person misdemeanor, which carries with it a penalty of up to 12 months in the county jail and or a fine up to $2,500. Do you understand that, sir?
Yes.
All right, this case is a South Half case that's been assigned to Judge Gettler. So I'm going to give you a new court date of July 30th, 2026 at 9 a.m. for a review via Zoom. That'll be via Zoom, excuse me. Anything further in Mr. Washington's case, Ms. Johnson?
No, Your Honor.
Mr. Lamson?
Your Honor, is there a bond?
Let me check real quick. There is a bond of $10,000 cash professional surety with report to bond supervision, ISO Harkey. That was set by Judge Gettler on June 29th, 2026.
I think that's appropriate, Your Honor.
All right. I've given you a new court date, discussed the allegations set forth in the complaint with you, Mr. Washington. Your next court date will be in front of Judge Gettler on that July 30th date. Okay, sir?
Okay, can I get a caution on speed of trial?
I'm sorry, I didn't catch that. What was that?
Can I get a speed of trial, please?
A speedier trial?
Yes.
You can discuss that request with Mr. Lamson, and he'll help you discuss the appropriate time in which to request that. Okay.
Okay, thank you. Can I see,
Thank you, sir. Thank you, Mr. Lamson. I think that's all I have for you.
Watch the defendant's box. His lawyer's gonna speak here, and it just tickled me how the defendant reacts.
Thank you, Your Honor. On Mr. Washington, it's very possible we'll need to do a competency evaluation.
Okay.
But I'll take that up with Judge Gettler.
Excellent. Thank you, sir.
Thank you, Your Honor. Thanks, Melissa.
He's just like, wait, what you say? What you talking about me? Pops his head right back in. It is Kansas. But let's just give it a minute here because the 30th was quite recent.
The state of Kansas versus Ernest Washington III, MGI 26 CR 211.
We have him across the hallway, Your Honor.
No problem. Thank you.
Mr. Washington, Your Honor. How you
Thank
doing,
you.
Doc?
I'm doing well. Thank you. Mr. Washington appears in custody by Zoom with, except from counsel, Mr. Lamson, stayed by Mr. Gayoso. This matter is set for review today. Looks like Mr. Washington had a formal first appearance of the charges in this new case before Judge Reynolds on July 7. Before we go any further, the court has received a number of correspondence recently from Mr. Washington that both requested a new judge and also they requested a new attorney. The most recent correspondence, it appears to me that Mr. Washington, correct me if I'm wrong, you no longer want a new judge. You are fine with me, but you still want a new attorney. Do I have that right?
Yes, I was just nervous and desperate. It's fine. I trust you, guy. I trust you, Your Honor.
All right, so we'll show that Mr. Washington is no longer requesting a new judge. Mr. Lamson, I don't know if you've had any recent communication with Mr. Washington or if you know why he is requesting a new attorney be appointed. Do you want to be heard on that, Mr. Lamson?
Yes, Your Honor. I've just had correspondence communications with Mr. Washington. It was going to be my request today that we move this matter to this afternoon so that I could speak with Mr. Washington. I have reviewed the discovery. Need to go over it with him, though, and I have received an offer from the state as far as possible settlement. So I don't know why Mr. Washington is requesting a new attorney. I've represented him in the past.
Just desperate. Just desperate and nervous. That's all it was.
No, being desperate and nervous is not a reason for a new attorney, Mr. Washington. But Mr. Gauss, are you opposed to this being moved this afternoon?
No, Your Honor.
All right, this is what we're going to do, Mr. Washington. We're going to have you transported to Coffeyville this afternoon. That will allow you to meet with Mr. Lamson in person. He can go over the plea offer that's been extended. You two can discuss whatever issues you might have with his representation, and we can discuss that in greater detail on the record this afternoon in person. So we'll take your case back up at 1:30 in Coffeyville.
Thank you, Your Honor.
We will see you then. Thank you.
I thank you. You're great.
This is State of Kansas versus Bryce Chapman, case number MGI 2026 CR 212. State appears by and through County Attorney Melissa Johnson. Mr. Chapman appears in person in custody from the sheriff's office, the jail laptop computer Zoom application. Case comes on for a formal first appearance. Mr. Chapman, a complaint information has been filed by the County Attorney's Office on June 29th, 2026, alleging 3 counts. I'm going to go over with you what the nature of those charges are and ask if you understand what you're being charged with, not whether or not you agree or disagree, okay? Count 1 alleges possession of methamphetamine that on or about June 27th, 2026 in Montgomery County, Kansas, that you, Bryce Chapman, did unlawfully, knowingly, and feloniously possess a quantity of methamphetamine. Possession of methamphetamine is a level 5 drug felony, which carries with it a penalty range of between 10 and 42 months in prison and or a fine up to $100,000 with 12 months post-release supervision. Do you understand the nature of that allegation, sir?
Yes, sir.
Count 2 alleges possession of drug paraphernalia as a misdemeanor. That on or about June 27th, 2026 in Montgomery County, Kansas, that you, Bryce Chapman, did unlawfully use or possess with intent to use drug paraphernalia, to wit, a glass smoking pipe, used or intended for the unlawful use in storing, containing, concealing, injecting, ingesting, inhaling, or otherwise introducing a controlled substance into the human body.
I might be crazy, but to me, it looks like he only has half of facial hair. Like there's a distinct separation, a line down the middle. There's beard here and none here. Maybe it's a trick of the lighting, but that's what I see.
Possession of drug paraphernalia is a Class B non-person misdemeanor, which carries with it a penalty range of up to 6 months in the county jail and or a fine up to $1,000. Do you understand that, sir?
Yes, sir.
Count 3 alleges possession of marijuana that on or about that same day in June 2026 in Montgomery County, Kansas, that you, Bryce Chapman, did unlawfully and knowingly possess a quantity of marijuana. Possession of marijuana is a Class B non-person misdemeanor, which carries with it a penalty range of up to 6 months in the county jail and or a fine up to $1,000. Do you understand the nature of that allegation, Mr. Chapman?
Yes, sir.
Mr. Chapman, do you intend to request an attorney to represent you appointed by the court?
Yes, sir.
All right, please fill out the financial affidavit that the deputy will provide to you. Return it. Do you know who's represented you in the past?
Mr. Lamson, a couple other attorneys. I'm not for sure all of them, sir. It's been a minute since I've been in trouble.
Okay, thank you, Mr. Chapman. Give me one moment.
Must be talking to each other.
Just talking to the clerk right now about your most recent court-appointed counsel.
It appears from our notes that it was Cole Hoffmeister.
Court is going to tentatively appoint Cole Hoffmeister to represent Mr. Chapman pending review of his financial affidavit. This case has been assigned to myself. I'm going to set it for this Thursday, July, I almost forgot the date, July 9th, 2026 at 9 a.m. for an attorney review via the Zoom application. We will notify Mr. Hoffmeister of his tentative appointment. Mr. Chapman, if you get that financial affidavit returned today, we can get you going pretty quick here on Thursday with counsel appointed, okay?
What about bond, sir?
Yes, good question. You have no bond. I'm going to set your bond right now.
I have money in the bank in Coffeyville at the teachers credit union. I just don't have nobody to co-sign for me.
Okay. Miss Johnson, is Mr. Chapman on probation or parole, which would trigger a special bond rule?
I am not sure. I will have to check. Could we move this to this afternoon and I'll have an answer for you?
Okay. But how about Thursday? Can we just we'll set up, I'm going to hold you, Mr. Chapman, without bond until Thursday, just 2 days. until the reason is there's a House Bill 2444. There's a new law in place regarding special bond rules. The county attorney's office, as well as myself, have to look into whether or not that special bond rule is going to be triggered or not in your case, which affects the amount of bond that is mandatory in your case. So I will set a bond for you on Thursday. Okay.
Is it gonna be high or is it gonna be?
Well, it depends on whether or not the House bill is triggered or not. So if you were on probation or parole with your criminal history score, which I believe is an A, it would be $50,000 minimum bond. If
It's probably not going to be as high as you, sir.
it's not, then there's no minimum other than an OR have to make written findings. Okay. So I will have a memo from Ms. Johnson's office, I'm sure, by Thursday, indicating whether or not that House bill is going to be triggered or not. Okay, sir? All right, I'll see you Thursday, sir. Thank you. And let's do Mr. Chapman next.
Okay.
That's a very recent appointment. I just first appeared him on Tuesday, I believe, Mr. Hoffmeister.
Okay.
Thank you. This is State of Kansas versus Bryce Chapman, case number MGI 2026 CR 212. Counsel, would you please announce your appearances?
Date appears by Melissa Johnson, Montgomery County Attorney.
Your Honor, Bryce Chapman appears in custody via Zoom with his attorney Cole Hoffmeister appearing via Zoom as well, but from separate locations.
Mr. Hoffmeister, as I noted, this is a very recent appointment. This is a possession of methamphetamine level 5 with accompanying misdemeanor paraphernalia and a possession of marijuana charge. I wanted to get Mr. Chapman on the docket so we could move his case along rather than waiting 4 more weeks. We do need to set a bond for Mr. Chapman, which is what the court was intending on doing today with counsel present. Ms. Johnson, I don't have a bond affidavit with regard to whether or not House Bill 2444 is applicable in Mr. Chapman's case. Do you have any update on that? He's going to be an A.
I was out of the office yesterday. I don't think he was on bond or on supervision at the time these occurred. I think he'd completed his prior case.
That's my understanding as well, Your Honor.
All right. Ms. Johnson, does the state have a recommendation on bond?
We would recommend $5,000 cash surety.
Mr. Hoffmeister, any comment? I know this is a very fresh appointment.
What is he charged with? I don't even know.
Possession, level 5, possession with some paraphernalia, misdemeanor, and a misdemeanor marijuana. That's it.
It's my understanding he still resides in Coffeyville. The court's familiar with him. He has not been in trouble for, I believe, the past few years.
Okay.
He would have no objection to reporting on bond supervision. I would ask for the court to consider a $2,500 cash or surety bond.
The court's going to agree with Mr. Hoffmeister. Considering Mr. Chapman is a criminal history score of A. I do believe he will be. However, the nature of the charges are drug related, and Mr. Chapman, I've known him to be drug is a major issue in his criminal life as far as his criminal history goes. So I do agree with Mr. Hoffmeister's assessment, and I do believe that a $2,500 cash professional surety bond is appropriate in Mr. Chapman's case. That would ensure his continued appearance before me as well as the safety of the community. I will add the condition of bond supervision for Mr. Chapman to make sure that he is reporting on bond. And I would also, Ms. Alexander, encourage if there is issues with regard to drug or alcohol treatment, please bring that to the court's attention, and I can add that as a stipulation of his bond. Okay.
Yes, Your Honor.
And if I could interject just very quickly,
Sure.
Bryce, do you anticipate being able to pay a bondsman $250 to get out?
I don't have nobody to sign my bond. I have money in the bank. I just don't have anybody to sign my bond. So if there was a way that I could,
Okay.
if I could get an OR bond and still stick to stipulations, I'll pay for the monitor or whatever. So
Trust me, bro.
that way, just to show the court that I am working with y'all or whatever, however you would like to do it. But if I could get an OR bond, that would be appreciated, because it's been years since I've been in trouble, man.
Yeah.
I've been doing the best I can.
Yeah, and I believe that, Mr. Kevin. Yeah, I will take that into consideration. I'm not going to give you an OR bond at this court date, but when you meet with Mr. Hoffmeister and he gets some more information, the court will entertain that option. Mr. Chapman's consistent with his statement with regard to, I think, having some money but needing someone to withdraw that on his behalf to pay for any of the services or any of the bond.
I got 160 on my books now, but I don't have nobody to sign for.
Understood. All right, go ahead, Ms. Alexander.
Okay, Bryce, if you make your bond, you'll need to come up to our office and fill out some paperwork and get reporting instructions, okay? Okay, thank you.
All right. Anything further, Ms. Johnson?
Just a new court date.
Oh, I apologize. Yes. Do you want a Zoom or in-person hearing, either August 6th or, in the AM or PM, Mr. Hoffmeister?
Well, Judge, I would prefer a settlement conference, but that's a Sedan City Court day. Can we set him for a settlement conference on the 4th in the afternoon and then
absolutely.
reset him back on a Thursday again?
Yep. All right, we'll go off docket and set a settlement conference on August 4th, 2026, 1 p.m. in person in Independence. Just, Jamie, make sure that we denote that this is a South Half case. Anything further, Mr. Hoffmeister?
Not at this time, Judge.
All right. Thank you, Mr. Chapman.
All right, thank y'all.
Mr. Gadlin, you're on.
Thank you. Is it Ushindi Gadlin?
Sure.
Say that first for me.
Yes, sir.
Okay. Ushindi Gadlin. Mr. Gadlin, you have been arrested on a probable cause affidavit, 2 probable cause affidavits submitted by the Coffeyville Police Department. The first one is internal case number 26-793. I've reviewed the affidavit submitted by Patrol Officer Stride, and I do find that there is probable cause for your arrest for criminal trespass, disorderly conduct, and interference with a law enforcement officer. Next, you've been arrested on a probable cause affidavit submitted by the Coffeyville Police Department in internal case number 26-794. I have reviewed the probable cause affidavit submitted by Patrol Officer Stride, and I do find that there is probable cause for your arrest for the offenses of criminal threat and battery. With regard to this last probable cause affidavit, the county attorney has filed a complaint information dated today, July 9th, 2026, alleging 2 counts. I'm going to go over with you what those counts are and ask if you understand the nature of those. Count 1 is criminal threat that on or about July 7th, 2026 in Montgomery County, Kansas, that Ushindi Gadlin did unlawfully and feloniously communicate a threat to commit violence, communicated with the intent to place another in fear. To wit, Jose Roig. Criminal threat is a severe level 9-person felony, which carries with it a penalty range of between 5 and 17 months in prison and or a fine up to $100,000 with 12 months post-release supervision. Count 2 alleges battery that on or about July 7th, 2026 in Montgomery County, Kansas, that Ushindi Gadlin did knowingly cause physical contact with another person, to wit, Jose Roig, done in a rude, insulting, or angry manner. Battery is a Class B person misdemeanor, which carries with it a penalty range of up to 6 months in the county jail and or a fine up to $1,000. Do you understand the nature of those allegations, Mr. Gadlin?
I understand the nature of the allegations. Yes, I do.
Thank you, sir. I appreciate that. One moment. Let me get through my little spiel here. A bond affidavit has been filed in the 26 CR 228 case, which indicates that pursuant to House Bill 2444, which is a recently passed legislation, that special bond rule applies, making your minimum bond $100,000 cash professional surety. Is that accurate, Ms. Johnson? Well, Ms. Johnson may have frozen again.
Can I ask a question, Your Honor?
One moment. I'm trying to figure out the county attorney's response here. Ms. Johnson?
Just for clarification, it should be 50.
That's okay. And you're breaking up a little bit for me.
Okay. It should be, for clarification, 50,000 for each case, 100 total.
Okay, so for both of the probable cause affidavits, internal case number 26793 and 26794, correct?
Sorry. They're going to be combined 50,000 total.
Okay, that's what okay, 50,000
Yes.
total for a umbrella bond involving both of the probable cause affidavits, correct?
Correct. He's also got separate cases
yeah.
that are already pending.
Yeah. All right. I've asked my question for Ms. Johnson. I've received the answer. Mr. Gadlin, you said you had a question for me. Go ahead.
Okay, now, as you guys say, these are allegations, right? Right? So the question I have is, how do you guys, how am I being charged with a felony, criminal threat, and a misdemeanor, what's the name, for something that I never did? That was never there for. I have witnesses on my side too that were there that know for a fact that I never came to those people at all.
Excellent. Just pump the brakes for a second. This is a hearing where I'm not going to hear the facts of the allegations, okay? I'm telling you that I've been presented an affidavit from a patrol officer. I reviewed the affidavit and I found that there's probable cause, which is a low-level finding, that the arrest was valid. The county attorney has reviewed the probable cause affidavit and has determined to file charges. You're innocent until proven guilty. You're completely correct, and you will have an attorney. So all of the information regarding eyewitnesses and defenses are applicable, but you need to present them through an attorney to the presiding judge, which is not going to be me. It's going to be Judge Gossard. Okay, so all of those are available to you. All we're doing here today is I was reviewing the affidavits to make sure that there's probable cause to support the arrest, which I have found, and I'm setting a bond for you, and I'm gonna give you a new court date. That's the only thing we're doing here today. Okay, Mr. Gatlin?
I'm saying there's no proof of me criminal threatening people. I don't know how you guys are simply saying criminal threatening people.
I've reviewed the probable cause affidavit.
That's hearsay though.
Mr. Gatlin, I understand that you're upset with the arrest. I am doing my job by reviewing the probable cause and I've affidavits to make sure that they're sufficient to support the arrest. I do find that the low level of probable cause is sufficient and has been met to support the arrest. Now, regarding a conviction, that's a much, much higher standard. So we'll get to that when we get to it in front of Judge Gossard. I'm going to set your bond at $50,000 cash professional surety pursuant to the special bond rules in House Bill 2444. As an umbrella bond to cover both cases. All right. I'm going to set these cases to run with your other cases in front of Judge Gossard on August 14th, 2026 at 9:30 p.m. That's a special setting. These cases will be on for a review, an attorney review is what we'll put them on for.
I thought Your Honor, I thought my case for Gossard was the 15th.
I have it written here as the 14th. I'll confirm that. I appreciate you asking me. I'll ask the clerk to confirm that. Okay, sir?
Yeah, Your Honor, I'm not mad at you. I know you're just doing your job. I'm just confused on this this new law. That's just wild to me. That's it. So if I come up with so is that cash or surety for 50,000? So I had to come up with 5,000.
Correct. Yeah, well, that's going to be between you and the bondsman. It's typically
I'm just asking. That's all I was asking.
Yeah. Mm-hmm.
And so now people don't need evidence for a criminal threat or a battery, none of that. It's just he say, she say.
No, that's not. You're confusing the initial step, just whether or not I'm reviewing the paperwork to see if the affidavit supports a probable cause finding for your arrest. Whether or not the arrest was justified or not, I'm making a determination on the arrest, not on a conviction. All right. There's a distinct difference there, Mr. Gatlin. Okay. So I understand that you're not happy with my probable cause finding to validate the arrest. I'm not making any determination whether or not that the allegations are would result in a conviction or not. Okay, sir. And Ms. Johnson, I don't know if you missed it. I set the bond, umbrella bond, on just the two cases, the probable cause cases, at $50,000 cash professional surety, finding that the special bond rules do apply to Mr. Gadlin's unfiled, well, one filed and one unfiled case. Can you confirm the special setting in front of Judge Gossard that that's the August 14th? It is, okay. I've set both of these cases for attorney reviews on August 14th at 9:30 in front of Judge Gossard, and I'll let Judge Gossard appoint counsel as he feels is appropriate.
Okay, thank you.
Anything further in Mr. Gadlin's case, Ms. Johnson?
No.
I have one question. What case is filed that you stated?
26 CR 228. I first appeared to you on it just a moment ago. That's the one involving criminal threat as well as misdemeanor battery, sir.
Okay, thank you, sir.
All right. Have a good day, Mr. Gatlin. I appreciate it.
Do my paper at me.
Okay, we are resuming court. This is the informal first appearance portion of the criminal docket for July 7th, 2026. I'm Judge Daniel Reynolds presiding. Ms. Johnson, the county attorney, is also present. Bring out whomever you like, Deputy.
Mr. Kirkpatrick, Your Honor?
All right, you are Daryl Kirkpatrick.
Yes, sir.
All right, Mr. Kirkpatrick, you have been arrested on a Coffeyville Police Department probable cause affidavit. I have reviewed the probable cause affidavit submitted by Patrol Officer Lynn, and I do find that there is probable cause for your arrest for the alleged offense of interference with a law enforcement officer. I'd also note, Mr. Kirkpatrick, that the county attorney's office has filed formal charges related to that probable cause affidavit in 26 CR 225. You are charged with count 1, interference with a law enforcement officer. That alleges that on or about July 6, 2026 in Montgomery County, Kansas, that you, Daryl Kirkpatrick, did unlawfully, feloniously, and falsely attempt to report to a law enforcement officer, law enforcement agency, or state investigative agency any information in a case of a felony, knowing that such information is false and intended to influence, impede, or obstruct such officers or agency's duty, to it, falsely reported that he had been robbed. Interference with a law enforcement officer is a severe level 8 non-person felony, which carries with it a penalty range of a minimum of 5 up to 13 months in prison and or a fine up to $100,000 with 12 months post-release supervision.
What was your end game? Why would you report that you've been robbed? Like, was it some insurance fraud scheme? Did you have a beef with someone and you were trying to pin it on that? Like, I have questions.
Do you understand the nature of that offense, Mr. Kirkpatrick? We're going to do 3 things here today, Mr. Kirkpatrick. I'm going to set a bond for you. I'm going to go over representation options you have, and I'm going to give you a new court date, okay? All right. A bond affidavit has been filed by the county attorney's office, which indicates that there is not a mandatory $50,000 bond that is discretionary as far as the amount goes. However, if I do find an OR bond is warranted, I'll make written findings. Is that accurate, Ms. Johnson?
Yes.
Mr. Kirkpatrick, before I set a bond, I need to ask you a few questions. Are you a resident of Montgomery County?
A resident in Montgomery County?
Do you live in Montgomery County?
I live in Coffeyville, Kansas.
Okay, how long have you lived there?
12 years.
Are you employed?
Yes, sir.
Where are you employed?
SP Boundary Security,
Okay.
Nights.
All right. Miss Johnson states position on bond.
Oh, did he just say he works security? That is not a wise thing to do when you're in a position where, your job is to report a crime that's been committed, and you're lying about crimes. That could bode very, very badly for your employment, sir.
We'd ask for $2,500 cash surety.
To get out? How much would it cost to get out?
Typically, that's whatever bond I said. If it's a cash professional surety, is 10% to a bondsman would bond you out. But that's going to be between you and a bondsman, okay? All right. Court will adopt the recommendation by the state and set your bond at $2,500 cash professional surety. Any request for bond supervision, Ms. Johnson?
No.
Okay. Mr. Kirkpatrick, you can hire an attorney to represent you at any point during these criminal proceedings. If he feels that you cannot afford an attorney, you can make application for a court-appointed counsel. You do that by filling out the financial affidavit that the deputy will provide you and return it. If you meet the financial qualifications, the court will appoint an attorney to represent you. Do you understand that, sir?
Yes, sir.
All right. This case has been assigned to Judge Gettler, and it's going to be a South Half case. So I'm going to set your next court date for July 30th, 2026, 9 a.m. Via the Zoom application that'll be on for an attorney review. Okay, sir?
Yes, sir.
Any questions for me, Mr. Kirkpatrick?
Yes, sir.
Ms. Johnson?
No, thank you.
Thank you, Mr. Kirkpatrick. Have a good day.
Thank you, sir.
All right. What is your name, sir?
My name is Juan Martin Diaz.
All right. Mr. Diaz, we're here today in the District Court of Ellis County, Kansas. We're here on an unfiled matter. You're appearing today pursuant to a probable cause affidavit that's been filed. According to this probable cause affidavit, you are looking at potential charges of possession of methamphetamine, a level 5 drug felony, interference with law enforcement, a level 9 felony, possession of marijuana, a class A misdemeanor, and possession of drug paraphernalia, a class B misdemeanor. We're here today to set your bond. Mr. Becker states position for bond.
Your Honor, I believe Mr. Diaz to be at least to be history based on my review of prior cases with him making both felonies, presumptive imprisonment. Also, I believe under that particular subsection of interference, this is a level 7 interference, not level 9. So my request based on the 2 felonies would be to set the bond at $7,500.
Damn, 75,000?
Mr. Diaz.
Sorry.
Mr. Diaz. All right, Mr. Diaz, I'm going to ask you for your position for bond. All right. I need to warn you, though, that this hearing is being recorded. So statements made today at this hearing could be used against you at future hearings. And so we're here today to talk just about the bond, not about any of the alleged facts that have led you here today. So the state's asked for $7,500 cash or commercial surety. Do you have a position you want to propose to the court?
Yes, Your Honor. Thank you for letting me speak. I would, is there any way I can get like an OR bond or anything? Because I've finished all of my supervision. I've completed all my supervisions successfully, and I have no problem reporting and doing my doing the UAs or whatnot. Even entering an Oxford house, I'll even do that. I'll even do that after I get all my stuff out of that house. I mean, if that's possible, great. If I get an OR bond, great. I obey the law. I just kind of.
Well, let's.
Yeah.
Mr. Diaz, so you said you got done with supervision. Were you on supervision for a prior felony conviction?
I have no supervision right now.
No, but were you on for a prior felony conviction?
Yeah.
Was it felony or misdemeanor?
Oh, well, yeah, I went to prison. I got out on parole, and then I finished.
Okay.
Successfully. Yes, sir.
Okay, you finished that. Okay, but it was prior felony.
What was it? I forgot what it was.
Okay,
Yeah, I forgot what it was, but I know I completed it successfully. I went through all the hoops that I was I went to all my meetings and everything, and you know.
All right. No, I understand that. But with the prior felony, current law then deems you as a presumptive public safety risk, and also a presumptive risk for a flight risk. So those are presumptions now because of your prior conviction. So the court at this point is unable to grant you an OR bond based upon that presumption. Now that presumption can be overcome by the hearing. And certainly if you want to overcome that presumption, you can file a motion and the court will have a hearing regarding that.
I've been on personal recognizance bond for 43 years. I don't have to report to anybody.
So,
but at this point, Mr. Diaz, the court cannot grant you an OR bond.
So you
the court is going
to want money then? You
Mr.
guys
Diaz,
want my money, right?
Mr. Diaz, this is time for you to listen. All right. So, Mr. Diaz, the court's going to set your bond at $7,500. That could be posted cash or commercial surety.
So what's
If you
the
post bond, Mr. Diaz, then you need to
I'm gonna-
obey by all standard conditions of bond, which are
Mhm.
following all laws, make all court appearances, stay in contact with any attorney, and make sure the court has the most up-to-date contact information. While out on bond, you shall not possess or consume any illegal drugs or alcohol, and you're subject to random breath, water, urinalysis testing for those substances. I'm going to give the state to August 6th at 10 a.m. to file formal charges. If they have not filed formal charges by that time, you will be released. If you bond out, your next court appearance will be October 6th at 8:30 in the morning. All right, Mr. Diaz, any questions for me?
Yeah, the bond, like, what is the 10% out of that 7,500?
But you can certainly talk to a bondsman. And the jail's got a list of bondsmen you can talk to, and you certainly work out whatever arrangement you have with a bondsman. And that can be posted through a bondsman. So, the jail's got those contact information. You can certainly contact them and work out whatever arrangement you have with them, okay?
So there's nothing, there's no OR bonds no more? That's what you're saying? Like, because the law passed, the new law passed?
There's new law for you specifically. There is a presumption now that new law passed, and there is a presumption that you are a flight risk and a public safety risk. You can overcome that.
Because I'm Mexican, that's why?
No, Mr. Diaz, you're not listening to me. All right, we're gonna be done, Mr. Diaz. That's not the reason why. It was a prior felony conviction.
Yeah. Oh, that's what it was? Okay. It was not even in my possession, man. Don't push me, man. You don't need to push me. You don't need to fucking do your head on that.
Good morning.
Ma'am, what is your name?
Jamie Williams.
All right, Ms. Weems, you're here today in the District Court of Ellis County, Kansas. We're here on an unfiled case. You're appearing today pursuant to a probable cause affidavit. According to that affidavit, you could be looking at potential charges of possession of methamphetamine, a level 5 drug felony, possession of marijuana, class B misdemeanor, and possession of drug paraphernalia, class B misdemeanor. We're here today to set your bond. Mr. Becker, state's position for bond.
Your Honor, I am aware of prior felony convictions for Ms. Weems, so I don't believe she is going to be eligible at this juncture for an OR bond. I would just ask bond be set at 5,000 cash or commercial surety according to the bond schedule.
Could I pause?
Ms. Weems, hold on. Hold on, Ms. Weems. So, Ms. Weems, I'm going to ask you for your position or a proposal for bond here in just a minute. I need to warn you, though, that this hearing is being recorded, so any statements that you make today could be used against you at future hearings. And so we're here today just to talk about bond. We're not talking about any of the alleged facts that led you here today. So the state's asked for bond in the amount of $5,000 cash or commercial surety. Do you have a different position you want to propose to the court?
Could I possibly get it like cheaper? Because like I was supposed to start my job today at 5 at Pizza Hut. And I don't have that type of money. I was gonna ask for an OR bond, but
Okay. Yeah, Ms. Williams, unfortunately, the law has changed regarding OR bonds, and with the prior felony conviction, you're right now presumed to be a flight risk or a public safety risk. You can certainly overcome that presumption through evidence, through a hearing, and you can file a motion and we can have that hearing. But at this point, the law says that you are presumptive to be a flight risk or a public safety risk, so I cannot grant you an OR bond at this point. So the court is going to, well, the court's going to set your bond pursuant to our bond schedule, and for a level 5 drug felony, that bond amount is $5,000. So the court's going to set the bond at $5,000. That could be posted cash or commercial surety through a bondsman. If you're able to post bond, you need to obey all standard conditions of bond, which are obey all laws, make all court appearances, stay in contact with any attorney, and make sure the court has your most up-to-date contact information. While out on bond, you shall not possess or consume any illegal drugs or alcohol, and you're subject to random breath, blood, or urinalysis testing for those substances.
is there a way I
I'm
can
gonna
come up with like services?
Hold on, Ms. Weems. I'll answer your questions in a little bit, but let me get through this, okay? I'm going to give the state to August 6th at 10 a.m. to file formal charges. If formal charges are not filed by that time, you will be released. If you are able to post bond, your next court appearance will be October 6th at 8:30 in the morning. All right, Ms. Weems, any questions for me?
Is there any way that I could get out with court services?
Again, Ms. Williams, I can't until that presumption, until I hear evidence regarding that presumption, I cannot grant an OR bond even supervised by court services. So if you want to have a hearing, a motion can be filed and I can certainly hear evidence regarding any overcoming of any presumption. But right now there is that presumption. So the can't grant an OR even with supervision with
So
court
I would
services.
need 500 with a bondsman.
Whatever, I don't know the arrangements with bondsmen, whatever you can arrange with a bondsman, it can be posted through a bondsman. So the 5,000 can be posted cash or through a bondsman commercial surety.
All right, thank you.
All right. Thank you, Ms. Williams. That's all I have for you.
Okay, Mr. Wicks.
Thank you very much, Your Honor. I've had the opportunity to speak with my client about both the charges against him, his plea options, as well as his rights. At this time, we'll acknowledge receipt of the complaint, waive formal reading, and enter pleas of not guilty as to both counts.
All right. And does Mr. DeGraff need a public defender?
Yes, Your Honor, and I do believe he's eligible to it due to his receipt of certain public benefits.
All right, Mr. DeGraff, I'm entering your plea of not guilty to both counts. I'll appoint a public defender to represent you in this case. And then, Mr. Talley, what's going to be the city's recommendation on conditions here?
Thank you, Your Honor, and good afternoon. The defendant, Mr. DeGraff, it looks like he's got a lengthy criminal history. In this particular incident, he had threatened to use a hammer against the victim. The city is requesting bail in the amount of $2,500, and we are requesting an anti-harassment order, no new criminal law violations, and return to all scheduled court dates.
Okay, Mr. Wicks.
Well, Your Honor, Mr. DeGraff vehemently denies the allegations against him, and after speaking with him, it looks like this one may go via a defense of others type of a defense. Of course, I'm not committing to the early in the case, but it certainly sounds like that based on our discussion. With that, $2,500 is far outside his ability to pay. As I mentioned, he's getting certain government benefits that certainly indicate he would not be able to make that amount of bail. So he's asking to be released today on his own personal recognizance, and that'll be his request.
Okay. All right, Mr. DeGraff has prior convictions for assault and for violation of protection order, and he has had warrants in his criminal cases since 2023. So, Mr. DeGraff, I think that you're a risk not to appear to court. I think you're also a risk to commit future violence and because you have done those things before. So I think the recommendation for a $2,500 bail is reasonable. That's what I'll set. Conditions of release: don't violate the law, don't possess firearms or dangerous weapons, and comply with the anti-harassment order that prohibits any contact with Chad Aaron Ogg.
If I may, Your Honor, please. I highly recommend against it, sir. There's almost nothing you could say at this point that would help you out, and a lot that could hurt you, I'm afraid. You're putting a woman in jeopardy by doing this. I'm just letting you know.
All right, we'll get a court date set for you. Court date's going to be August 18th at 10 o'clock. Right?
Gracious.
All right, Mr. DeGraff, we'll see you then. All right, and sir, at Nisqually, Olympia, what's your name, please?
John Sal. John Sal. John Sal.
Gotcha. Okay, and Mr. Sow, you're here today because a warrant was served on you.
Yes.
It's like you missed your arraignment initially in this case, so we'll do that here today, all right? You're charged with the crime of criminal trespass, and the city of Olympia alleges that that occurred on December 4th of 2025. Mr. Wicks?
Thank you very much, Your Honor. For purposes of today's hearing only, I will well, actually, it looks like PC's already been found, so don't need to do that. I've had the opportunity to speak with Mr. Sow about the charges against him, his options and his rights, and at this point, we'll acknowledge receipt of the criminal complaint, waive formal reading, and enter a plea of not guilty as to the count of criminal trespass.
All right, Mr. Sal, will enter that plea, not guilty.
Yes.
Okay, and does he need a public defender assigned?
Yes, he will, Your Honor, and I believe he's eligible.
All right, I'll appoint an LMB a public defender for you, Mr. Sal. And Ms. Vitale, what's the city's recommendation on release?
Your Honor, if you look at Mr. Sal's criminal history, it looks like he's got warrant activity on most of his cases. I believe he currently has an active warrant. Understanding the nature of the charge as a criminal trespass, the city is only requesting bail in the amount of $500, no return to the Union Building, no new criminal law violations, and return to all scheduled court dates.
Mr. Wicks?
Certainly no objection to a PR release, Your Honor. If we can get him notice, hopefully we'll be able to resolve this rather quickly.
All right, Mr. Sal, I am going to release you on this charge. Conditions while the case is pending are don't violate the law.
Thank you, thank you.
And I'll give you a court date. Okay.
Thank you, Your Honor.
10 will be your court. All right, that's going to be printed off and given to you. You don't, does he, I'm sorry, Mr. Wicks, did he give us a method of contact or is it just?
I'm sorry, you kind of broke up there, Judge. What did you say?
Did he give us another method of contact or is it just the hearing today to notify him?
I think it's just going to be the hearing today. So I've advised him to call the court in about a week to try to figure out who his public defender is and get their contact information. Because unfortunately, he doesn't have a consistent means of contact at this time.
Okay.
And Your Honor, your audio was cutting up a little bit. I did not hear the return date for pretrial.
September 1st.
Thank you.
10 o'clock.
Okay.
All right. And Mr. Sal, feel free to call the court as often as you'd like to get reminded of your court date. All right. It's better that than you forget it and miss it.
Yes.
Okay. You're good to go, Mr. Sal.
Thank you. Thank you, Your Honor.
Okay. And sir, over in the other Nisqually booth, just have a seat there in front of the camera and tell us your name, please.
Aisha Heard.
Okay. Go ahead and have a seat there, Ms. Heard.
Thank you, Your Honor.
All right, and today you're here in court because a warrant was served on you. It's like you missed a probation hearing on your Lacey harassment case, and that was back in March.
Your Honor, I didn't receive the proper email. Since my last court date, I moved to the city of Seattle. So I lost several paperwork and things like that in getting settled in. So I didn't get the chance to fax over the mental health information.
Know about it?
The evaluation. No, I knew about it. I in moving and translation, I didn't get to fax over the mental health evaluation to the court.
Okay. All right, Mr. Swinson.
Sorry, Your Honor. Who is this?
Ms. Heard.
Yeah, Ms. Heard. Okay. Well, Your Honor, yes, I am asking the court to release Ms. Heard on her personal recognizance today based on the information that she provided. She wasn't aware of court and has relocated. But if she's given a court date today, she will be able to appear in the future.
The other issue in her case, besides the mental health evaluation, is new law violations as well. There's been a couple of convictions since she was sentenced. One of those is for false statement in King County District Court, and the other is for theft in King County District Court. All right, Mr. Sharp.
Thank you, Your Honor. So a bit of nuance with that. She had a couple cases in Lacey and they had disparate conditions, and this case is the one that resolved in November of 2025. So only one of those new law violations applies. City is moving to revoke. Previously, cities moved to revoke probation on this for no proof of mental health treatment. Today, the city adds new law violation 6A340836 out of King County. I do anticipate filing a motion on her other case that's not before the court today as well. But on this one, city's asking for $500 bail. We've had warrant issue on this case before. According to the city's records, she was originally held on bail back at arraignment. She has extensive warrant history, which suggests she's not likely to appear. As the court just heard, she has relocated. That is supported by the fact that she was recently convicted of a new crime, not in the next county, but a couple counties over. So city believes 500 is necessary to assure her appearance.
All right, and Mr. Swenson, where's she living now?
I don't have the address, Your Honor, but in Seattle, King County.
Do you want to take probation action on this case today and end it?
Yeah.
Sorry, Your Honor, just a second.
Yeah, city be prepared to recommend 10 days as a sanction, close the case out, and we would consider that addressing the other probation violation as well. Not file a motion on that if we resolve it today.
How much thinking do you need to do about that, Mr. Swenson? Probation that your client will not comply with, or closing the case out. She serves 10 days, she's done. No more chasing her. No more missed screens. No more court dates. She was enthusiastic about it. You should be doing cartwheels.
We can resolve today, Your Honor.
Does that recommendation sound reasonable?
With credit for time served, so yes, Your Honor.
She'd have credit for 1 day served, and then Mr. Sharp had recommended 10 days as the sanction.
Okay. If it results in closing the case, I think that's reasonable.
All right, I think that's reasonable too, because Ms. Hurd is, I don't think, going to realistically be available for probation since she's relocated, and it's already been 8 months now and there hasn't been any progress. So there'll be 10 days for the violation, credit for 1 already served, so 9 days left to serve, and then this case is closed. All right, so Ms. Hurd, once you get done with that, the next 9 days, then you'll be released on this case and you don't have any further obligations to us.
Thank you, Your Honor.
Okay. Thank you, Ms. Hurd. You're good to go. Okay. While that is going on, we'll go over to the Nisqually Olympia booth. And ma'am, what's your name, please?
Rebecca Daldiger.
Okay.
And so she's on Olympia, Your Honor. I didn't have the opportunity to speak with her. I'm not sure. I didn't get notice that she was a single cell. I think it might have just been a running out of time situation, but I would need to speak with her off the record before court.
Okay, Ms. Doninger, just go on back with the corrections officer, and Mr. Wicks will be giving you a call here in just a second. We'll call your case back in a minute.
Thank you.
All right, I see we've got Ms. Doninger back. Mr. Wicks, are you ready to address her case?
Those meth sores on her face have only had her time in custody to heal. She looks like she walked off the cast of The Walking Dead. I truly hope that this woman finds sobriety.
Yes, Your Honor, I am. I've had the opportunity to speak with her at this point. So this matter comes back on a warrant return. I believe she's already been arraigned and all that. Mr. Hofstad's been assigned to represent her. So at this point, I think we just need to get her a new court date and ask that she be PR'd so that she can work with him on that. I would note her relative lack of criminal history. She has a case out of Clallam County Superior from believe 2017, where that case is listed as a conviction, but I would note under State v. Blake, each of those counts should probably be vacated at this point. Her only warrant history that I see is from that case that is vacatable. Her only other conviction is a nonviolent taking motor vehicle without permission. So at this point, she's asking to be released on her own personal recognizance to work with Mr. Hofstad on this. I know it would be a big help to him to have her out.
Okay, the problem here is that the warrant was issued when she failed to appear at pretrial services and comply with her release conditions. And then she missed court a couple of days after she didn't appear to give a UA as ordered. So that raises some obvious suspicions that I think we're all thinking about. Ms. Batali, what's the city's recommendation on her current release?
And I do understand that, Your Honor. But I also agree with the defense in the sense that her criminal history, she does not have a history of failing to appear. So I'm in agreement today to give her one last chance. I would ask that she report to probation by Monday, by the end of day. And if she doesn't, that the city would request a warrant off the record if she does not appear at that time.
What do you mean she doesn't have a history of failing to appear? The judge literally just spoke of 2 instances that she didn't appear when she was supposed to. Maybe she doesn't have an overall history throughout the years, but she certainly has a recent history, probably based on her substance use that she is clearly rekindled.
Okay, pretrial services though, not probation.
Yeah, I apologize.
Okay, Ms. Donger, I'll release you, but you've got to report to pretrial services right away,
Yes, sir.
okay? And
Yes,
part of
sir.
your release conditions is abstinence, and the way that's being monitored with you is UAs that they request from you from time to time. So do not miss those, okay?
Thank you, Your Honor.
Okay. Okay, and you're coming back to court on September 1st at 10 o'clock.
Okay, I will see you then.
All right, thank you.
Thank you. When did they come out? Okay.
Defense has been notified of any refusals today that we could.
Just so that we're clear on this last case, is she ordered to report to probation by Monday at 5 p.m.?
Which case?
On Doninger?
She's got to report to pretrial services
Or,
on
sorry,
Monday. On
Pretrial
Monday.
services, Monday, okay.
All right, sir, over at Nisqually Olympia, what's your name, please?
Paul Mokes Burns.
Okay, Mr. Burns. Mr. Burns, today you're here in court for your arraignment. The charge against you is assault in the 4th degree, and the city of Olympia alleges that occurred on July 28th. Mr. Wicks.
So, Your Honor, I had not had this opportunity to speak with Mr. Burns. I need to make a bit of a record. So I'm looking at his recent criminal history that includes multiple cases dismissed due to a lack of competency. I'm noting I've read the police reports, the facts in that coupled with his appearance today in court. I think I need to file an order for a competency evaluation.
Now, he has another case that's in a pretrial status with the city of Olympia. Mr. Rusnak is his attorney in that case. And let's see, at this point, he had appeared earlier this month, been arraigned, and future hearings were set. Nothing ended up happening because he was placed into custody on this latest charge. So he hasn't made any other court hearings because none of them are scheduled yet until August 13th. So you're concerned about his current competency?
Having looked at his his history, the fact that we have multiple refusals here, his presentation today in court, yes, Your Honor, I do.
Okay, Mr. Burns, can you hear me okay?
Yes, sir.
Okay, do you know what you're doing here in court today?
I'm here for the charge of assault.
Do you remember what charge I just read to you?
Assault in the 4th degree, I think.
That was it, yeah. Okay, and then do you remember being in court with me earlier this month on some other charges?
Yeah, I didn't recognize your face. You kind of look different for some reason, sir.
That's okay, you're looking at me over a screen. Okay. Do you remember what the charges were that you were in court for just a couple weeks ago?
I know one of them was resisting arrest or something with the police, and I don't remember the other ones.
Okay. Can you tell me the best you can remember what happened at that court hearing a couple of weeks ago?
You told me that I'm supposed to appeal on the 13th, 13th of next month.
Mm-hmm. I did tell you that. I did tell you that. Okay. All righty.
Seems like he can assist in his own defense. He's got a memory on him. That is an ironclad trap.
You worked with an attorney on that court hearing a couple of weeks ago. Do you remember her? No. Did you deal with her on the phone?
I don't remember that. I don't remember that.
You don't remember that? Okay. All right. All right. And hang on here. There aren't very many records here. The last time Mr. Burns was found to be not competent was by this court in a Lacey case, but that was in 2016. It's been a while. Okay. And then I see corrections is there in the booth with Mr. Burns. Can I ask if you know how Mr. Burns has been doing the last couple days over there in the jail?
Yes, Your Honor. Mr. Burns displayed some concerns with mental capacity. He often talks to himself in the cell. His cell is unsanitary, not clean, refuses to shower, doesn't really sleep well.
What it is, sir, I've been around a lot of people that be doing drugs. I've been on the street for so long, and I've been around there for so many years. I grew up in church. And when you grow up in church, you be like a holy one, how Jesus' prayer was, Once you be around things like filth, it turns you different.
All right, Mr. Wicks, I think your plan is the way to go here, and I'm going to order a competency assessment for Mr. Burns.
Would Your Honor like me to, what's the best way for me to get a order for eval to the court?
Look, the in custody desk.
The in custody desk.
Yeah.
Since Ms. McCarran normally is doing this for our firm, what's the email for that again?
Okay, just stand by and that'll come over in the chat.
Thank you.
All right, in the meantime, we're going to have to determine whether Mr. Burns needs to be held for this evaluation or whether he should be released to do it in the community. Ms. Vitale, do you have a position on that?
I do, Your Honor. You mentioned the charge earlier in the month, and then I know he's got these older assault and harassment convictions from 2016, but given that he's violated conditions of release on that charge from earlier in the month, I do think he should be held, and I'm asking the court to hold him on bail in the amount of $1,500. We're also requesting a no contact order in the assault case. No new criminal law violations, return to all scheduled court dates.
All right, and Mr. Wicks, do you have an opinion on that?
Your Honor, having not spoken with him about that objective, and I'm not sure he's able to form an opinion about that objective, I take no position.
All right. I'm gonna set bail at $1,500 in each of the two cases. And I'll leave the door open for any future bail arguments if there's any additional information on that issue. And we'll set competency hearing. I'll set that for August 14th on the 1:30 calendar. And we can review the competency evaluation early if we get it early. Okay, Mr. Burns. I'm gonna have a psychiatrist come talk to you and prepare a report for us. And then once that's ready, we'll have you back to court and figure out where we go from here, okay?
Yes, sir. God bless y'all.
All right, so you go ahead with the officer now.
Yes, sir.
Thank you.
Mhm.
I really do hope the best for him. I mean, lotion on his face and all. There's clearly something going on that he needs help with. And also judge the people. That goes for the Kansas guy, too. Yeah, a few years ago, I decided that I wanted to make contact with someone that I went to high school with. And I mean, we weren't ever really close friends, but I always kind of had a crush on him. And I only saw him once after graduation. He came to, I was working at a but it was once Blockbuster. I can't remember what it became. But anyways, I was working at this movie rental place, and he stopped in to get something to rent, and we chatted for a few minutes, and I learned he was going to college. He wanted to manage motels. Thought that was amazing. And he was always someone that I found a very genuine personality of, and I really liked him. I really admired him. So fast forward, a couple decades. Pretty much. No. Fast forward several years, and I decided that I wanted to make contact with him and just check up on him, see if he ever finished his degree or, whatnot. But I couldn't find any social media presence whatsoever. No accounts, which was odd to me. Well, I found out from another person that we went to school with. I brought him up, and they said, oh, no, he developed schizophrenia really bad. He would never have social media. And it floored me. Sorry guys, my daughter's texting me. But it threw me for such a loop, because even though he and I were not super close friends, we were always very friendly, and like I said, I found his personality to be so genuine and remarkable. Something you just don't find in a lot of people. And then to find out that he had schizophrenia, I guess it came on really quick. And it was in his early 20s, I think they said. But yeah, it bothered me. It bothered me to know that. Because he was such a great guy. He may still be. I don't know if he's in treatment or taking meds or how he's doing, but definitely wish the best for him. Well, and who knows, it could have, and maybe they didn't see the signs. You've mentioned that, Nana Laura. Is he doing okay now? Well, your mother doesn't live in the night. I'm a lady of the night, but not that kind of lady of the night. No, my daughter used to make these stop motion pictures. Well, stop motion videos. And she's so excited that she found a new software to make them. And so she sent me her first one that she made, and it's so cool. She does it of paintings that she paints. She makes little, they're only like that big, and she uses that wasabi tape, and she tapes off a rectangle in her diary, and then she paints, within that rectangle, and then when she peels the wasabi tape off, she has perfect edges. But anyways, she made a hammerhead shark. I love it. It's so cool. She won't let me share her stuff though. She has rules and boundaries, and she doesn't even really like me talking about it, but this is my baby girl. How can I not? I'm so proud of her. I wish I could. But I have to respect her boundaries. She's always been very clear about boundaries that she sets, and it would hurt her if I crossed the line. I know that because I tested the waters before, and it never went well for me. It only drove a deeper wedge. Very, very similar to claymation, but with painting instead of claymation. But it is almost like the same thing. It's just she's painting a picture, and so you see the picture come to life as she's doing it. It's kind of like when I was a kid, there were shows that would read you children's stories, and they were animated by painting claymation or drawing claymation. The pictures would, you'd watch them draw it, and then it came to life, and and that's what she's making. And so it's really neat for me to see that in her generation being a thing, when in my generation that's what cartoons were. Ha! We're all tied together, I swear. She posts some of her own things she's on like some artist pages, and she enters the stuff into contests and wins. I mean, she's really darn good at what she does. I'm sorry. I can't even send it to you, Mortimer Duke, because you told me you can't receive videos from me. I know you can't listen to voice to text audios. I don't know, maybe you were lying to me. Wasn't he though? No. I swear, I thought one of the new state quarters, I thought it was Bob Ross on it. Hold on. Let me see. It wasn't though. But it looks so much like him. I know I saved some of them in her jar. Hold on. We're gonna play this game. I think, you know what, I got better luck in this pile. Let's see here. Kentucky, just a regular one. Let's see here. War in the Pacific. Homestead. Disability. Girl Scouts. Disability. I don't know what's up with that one. Wire Farm. Girl Scouts. What was that one? Shenandoah. Come on. I want to find that quarter because I want to show you. Whoopsies. Knocked over my drummer boys. I'm making a mess of my desk here. Good night, Penny, honey. Alright, not that one, not that one, not that one. 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 Dag nabbit. I don't have one out. Anyways, there's... When I find one, I'll show it to you guys. I'll post it. I'll post it on Discord. I have, you know, 24 of them. I just don't have 24 of them sitting here on my desk ready and waiting because I didn't know I was going to flap my gums about it. As, I should have known. I should have known. I don't know what this pile is. What's this pile? Huh. Oh, okay, I know what that pile is. Yeah. Anyways, that's what I got for cases tonight. And then I did live long and prosper in the intro. I did. Dark Zoomy said, "May the force be with you always," and I just couldn't stand on that. I swear, like, we cross paths so often with, things that we think, say, and do all at the same time without even realizing it. Just that right there. You didn't? Oh, you did see it. Oh, okay. You were lurking. All right. But still, like, I had no idea that you watched that movie. I had no idea that, you watched anything about sharks, and we connected on both of those. I don't know. I think that many of us are connected in ways that we'll never be able to explain, but that's why we feel so familiar to each other. Like, C-Rex was my another mother, like, instantly. The first time she saw me. You were my brother for... I was calling you Uncle Charlie to the cats. Buzzy Pug was my sister. You put her profile picture up above my thumbnail. We look a lot alike. So many of us have so much in common. Family. Best community ever. Oh, Aren't those relatively rare? I know they get a lot of talk, but overall, aren't they pretty uncommon? I might be wrong. Our birthdays being very close. 2 days. Me being able to read Jerry's text most of the time. I was the first one that could. Well, that's not shocking. They're also number one in the high prices of stuff. Yeah. Super expensive. Priced out of paradise. That's what they call it. There's I used to babysit for a lady when I was yeah, and our daughter's birthdays. I used to babysit for a lady when I was preteen, and she was one of the early priced out of paradise people, and she and her parent she'd go back to visit her parents, and she would have to bring like jars of maraschino cherries from what's that place, like Costco or Sam's Club, the giant jars. She'd have to bring those because a little jar was $18. And that was when I was 12, 13-ish. Yeah. And I couldn't believe it. I always thought it would get better, but it never did. It got worse. And they have, you can live outside all year round pretty much. So many do. But anyways. No way. I hear that's where the Simones come from. You guys are a trip. Oh, seals are actually quite vicious. They are cute to watch in captivity, but they are a force to be reckoned with. I love the Learning Channel kind of things. Top notch. Oh, all right, guys. Thank you all so much for coming and hanging out with me. I love every one of you. I truly do. And hopefully I can find good stuff for us tomorrow. Rumor has it my baby girl is coming to visit me. Well, okay. She needs stuff, but it counts. You guys are the absolute best. Be safe, be well, sleep sweet, and much love.